Hello, everybody. It's Malin here at Anderson Law Firm. Today we are discussing part 2 of Dave Ramsey's Curious Estate Planning Advice. And here is James to get right into it.
Thanks, Malin. Hi, everybody. Welcome back. Hopefully you've been following along since last week. If not, for purposes of getting you caught up, I am, I don't know, I'm picking on Dave Ramsey as a way of trying to introduce core estate planning topics to the population at large. Last week, we discussed some comments that Mr. Ramsey has made publicly through his radio program and through his website and other materials on multiple occasions over, frankly, spanning quite a few years, a consistent message that no, all someone needs is a will, and better yet, go to uslegalforms.com and buy one and earn me a commission. That's all you need. You don't need trusts. Trusts are for rich people at best, and at worst, they are gimmicks. So last week, we started to unpack that. We talked about what wills do, what they don't do. We talk about how wills just serve to control what happens to those assets that go into probate when we die. It does not take into account assets, the disposition of assets that pass by way of beneficiary designation or by operation of law. Does not contemplate incapacity. Does not contemplate healthcare planning. And I kind of closed last week's presentation with a thought that, in my opinion, for the vast majority of people, if you're going to execute one estate planning document, it probably really needs to be a durable power of attorney and not so much a will. But I'm not going to go through all that again at this stage. If you did not see last week's presentation, go and check it out. It should be on our Facebook page, and we're also getting a YouTube channel set up as a resource. So if you're just getting into this, take a step back, go to last week's presentation, Dave Ramsey's Curious Estate Planning Advice, Estate Planning Fundamentals, Part 1. So today is Part 2. We are picking up where we left off. So we went over some lengthy quotes from Mr. Ramsey. I'm not going to rehash all of those today, but I do want to go back to one that we previously discussed, where Mr. Ramsey was asked by one of his listeners to explain the difference between a will and a trust. And Mr. Ramsey says, everyone needs a will but not a trust. You leave money in a trust by virtue of your will. The will tells everyone what to do with your stuff and your kids when you die. The will can say, leave the money in trust for your kids. You need a will, but not necessarily a trust. The living trust costs up to $4,000 and is highly pitched, but is overdone in the estate planning world. It's not needed nearly as often as people say. It's more of a gimmick. You save on probate taxes, but you operate your life in a trust, which is a pain in the butt. All right, so, before I really start to, get into the meat of all this, the lawyer in me must first present a disclaimer, and that is that I am not giving you legal advice. If you are watching this, on your computer, via Facebook, whatever the case may be, this is not legal advice that I am giving to you in your particular situation. This is general educational information. I am trying to educate folks. I am trying to help people issue spot when it comes to common estate planning concerns. My hope, my objective is that these videos will allow people to, look at their situation from a more educated and empowered stance. But no, I'm not giving you legal advice. That involves you coming in to speak to me or somebody like me, and actually look at your particular situation, your particular facts, because those will dictate the type of specific advice given. Okay, so this is not legal advice. If you want legal advice, go and find yourself a lawyer. Okay, so that having been said, is it true that all we need is a will? All right, fine, maybe, sure. If you know that all your assets are going to pass through probate, and over and above that, you're okay with that. Fine. If all your estate is going to go through probate, then your will absolutely control what happens to those assets, and mission's going to be accomplished there. Okay. A will is also all you need if over and above that you don't care anything about incapacity and healthcare planning. Fine. If you're not worried about what would happen in the event of a protracted long-term care scenario or incapacity. If you don't want if you don't care anything about your loved ones having to pursue a guardianship or conservatorship for you, having to sue you in probate to obtain those things in the event of your incapacity, fine. All you need is a will. Great. But I think that the vast majority of us would not fall into those categories of people. So, which really begs the question, kind of goes back to this whole will versus trust dichotomy that Mr. Ramsey set up in that particular exchange. What is a trust? Well, really, at the end of the day, there are two kinds of trusts, and this confuses people many times. I don't want it to confuse you. There are revocable trusts and there are irrevocable trusts. And for our purposes today, we're going to talk about revocable trusts. All right. We'll save irrevocable trusts for another day and another conversation. Now, if I prepare 100 trust agreements, probably 96 or 97 of those are going to be revocable trusts. Revocable trusts are commonly called living trusts. And so if you're out there in the wild and you hear the term living trust batted about, that's what we're talking about. We're talking about revocable trusts. Now, as the name suggests, revocable trusts are revocable. They are not set in stone. It's something that if you set one up, typically you would do that through a trust agreement where you are the only trustee and the only beneficiary of your trust for as long as you're alive and not incapacitated. These trusts are, as I often say, alter egos of yourselves. All right, you set one up. You are sovereign king or queen over your respective trust domain. Okay, now the trust agreement itself it reads like a will. The trust agreement says, well, okay, as to the stuff that's in my trust, first of all, at my death, this is who takes over for me. We call that person a successor trustee. They operate in a executor or administrative type function. You say, this is who takes over for me. These are the administrative things that I want this person to do. These are the gifts that I want to be made and how I want those gifts to be made. Okay? So again, in that regard, it reads an awful lot like a will within the context of probate. All right? A particularly good trust agreement will devote quite a bit of real estate to incapacity. And in that sense, a good trust agreement also reads like a durable power of attorney. The trust agreement says, well, all right, if I'm incapacitated, this is who takes over for me, and this is what I want them to do with my stuff. All right? So the core advantages of a trust-based estate plan, the real novelty of a trust-based estate plan is, first of all, in one fell swoop, the trust takes the place of wills and probate. Okay, if we have a trust and we put assets into that trust, those assets are going to be controlled under the terms of the trust while we're alive, God forbid upon our incapacity, and ultimately at and beyond our death. Okay, so fundamentally, what the core threshold foundational advantage of a trust-based estate plan is that whatever goes into the trust does not go through probate. It passes privately under the terms of the trust agreement itself. All right. So, with respect to the death scenario, things are passing privately under the trust agreement. That is saving, in all likelihood, a year and a half or longer of somebody's time, and it is saving probate-specific cost of administration. All right, and that's great. When it comes to incapacity, The advantages are, frankly, significant compared to what would happen in a vacuum. Not only do the assets that are in the trust, not have to go through probate to be subject to a guardianship or conservatorship action. You're able to, through the language used in the trust agreement, to really specify with a high degree of nuance how you'd want your resources to be leveraged during your incapacity. So, for instance, you say we're talking about my trust. I could say, all right, I talked to my wife, Kate, from my incapacity. I say, Kate, I'm incapacitated. You're in charge. You're the trustee in my trust. You control all my stuff that's in here. This is what I want you to do. I could do like the probate court would do. I could say, well, Kate, I love you, but I don't trust you entirely. So you best lock down whatever it is that's mine, and you're going to use that to take care of me and only me, or else, there are going to be consequences to suffer. Of course, as you might imagine, I'm better trained than that. And what I actually say is, I say, all right, Kate, I'm incapacitated. You're in charge. This is what I want you to do. Yeah, please use my stuff to take care of me, but also, take care of you too. There's no my stuff and your stuff. It's all mixed up. Take care of me, take care of you, take care of us. We don't have any children, at least not of the two-legged variety. But if we did, I could say, hey, take care of them too. We do have four-legged friends, so I say, Kate, take care of me, take care of you, take care of the critters. You can even do things like give your trustee the discretion to be able to continue to tithe or continue to engage in any kind of habitual gift-giving patterns that you exhibited prior to your incapacity. And we can go on. But with all the a good trust-based plan offers so many administrative advantages, but when it comes to the incapacity frontier, really and truly, a good trust-based estate plan offers us the best incapacity planning tool that there is. Period. Okay. Now, over and above those administrative advantages that the trust offers, I'd like to say, having the trust there to begin with paints us up a target that we can then point all of our assets into. Okay, that we can go ahead and put our real estate in there. We can go ahead and put our business interests in there. We can point our life insurance, and if it's the right kind of a trust, we can point our retirement plans into the thing through beneficiary designation. Bank accounts can be pointed in there. Whatever it is you have can go in that trust fund. And that whatever you have that points into that trust at your death or upon your incapacity is going to be handled under one master set of rules and plans and contingency plans. So you got your plan A, B, C, D, E, F, and G all in one place. If somebody that was supposed to survive you did not, that's terrible. That's terrible. But at least if you were doing decent planning to begin with, that contingency had been planned for ahead of time. And you know reliably what to expect to happen there. Okay, so if something happens to somebody, you're not having to go and change a bunch of different beneficiary designations, right? You're not having to go to the bank and change your PODs. You're not going to have to go to your financial advisor and change your transfer on death designations on your brokerage accounts, for instance. If a change needs to be made, it's made one place at the trust level. Again, it's one-stop shopping, as I call it. Everything in this nice little package with a bow on top. Okay, Mr. Ramsey acts like, well, you're having to live your life through a trust. Well, what difference does it make if the trust is you? If your house is in your trust and you need to sell your house, you sell your house. It's not a big deal. You give a document called trust certification to your closing attorney so that they know that you're the one that has the authority to sell your house. It is no different mechanically than real estate investors wisely using legal entities like LLCs to own investment properties. If they need to sell one of their properties, they can just sell it out of their LLC as long as they have managerial control over that entity. It's not a big deal. It really isn't. And those who would say differently, like Mr. Ramsey, are at best ill-informed and at worst perhaps have ulterior motive. And again, I'm thinking uslegalforms.com. Now, I'm going to give you a little teaser here. So we are I'm about to shut down this presentation for the day because I don't want to rush the next planned presentation that we have because we are at the cusp of being of venturing into what I call the fun side of estate planning. All right. Now, one of the really, really nice things about a good trust-based estate plan is that, not only does it keep everything that's in the trust out of probate, not only does it provide for a master set of contingency plans that apply to everything that flows through that trust, not only does it privatize everything, so you don't have to worry about your surviving, say, widow being approached by these bottom feeders that comb the probate courts and look for new estates opened and see where someone has died and try to strong arm or intimidate surviving spouses or children into giving away the house just so they can flip it or even just wholesale sign the contract. So over and above centralizing the wealth transfer plan and privatizing the wealth transfer plan and planning for contingencies, what a good trust-based plan will allow us to do is to be able to efficiently structure and protect and preserve those gifts that we leave to those closest to us. Okay? It is counterintuitive, but the reality is that if you know what you're doing and you play your cards right, you, me, Malin back there, any of us are able to exert more lovingly beneficial control, more shepherding control over what we have from the grave as we give it to those that come after us. Yes, I realize that doesn't make a whole lot of sense, but stay tuned. I'm gonna explain all that to you and hopefully make minor experts of wealth transfer options of each and every one of you. So that having been said, we'll begin to shut it down. Again, does everyone need a will? I would say probably not. At the very least, you need a power of attorney. You only want or need a will if you want or need for all your stuff to go through probate. And I think if we were to poll the vast majority of people that come in here, new clients that come in here, many times because someone close to them died and they had to probate someone's estate and they don't want their family to have to do that, I think you'd find that most of those people would beg to differ with Mr. Ramsey. So wills are not end all be all. If you want an estate planning mechanism that will do what you want to do in a private format that will save money on the back end, there is no superior method than a good trust-based estate plan. Period. That's in the story. That's what my wife and I have. That's what I've done for my mother-in-law. That's what I've done for my mom and dad. Betsy, who many of you might know, the other attorney here in my office, who among other things does probate for us, that's what she and her husband have. Okay? Contrary to what Mr. Ramsey would say, and frankly I take great offense to this, revocable trust or living trust-based estate plans are not gimmicks. They're great. Pretty much anybody should have one. So if you have any more questions about this, I encourage you to speak to your attorney. If you don't have an attorney, by all means, come and give us a call, and we'll be glad to actually look at your particular situation and offer you some legal advice rather than general educational information like we have here tonight. So, All right, I think I'm about spent. But until next time, I wish you happy trails and happy estate planning, and we'll talk to you next week.